I'll start with you, Mr. Fuseni. This week, the EC chairperson, the trouble surrounding the Electoral Commission simply didn't go away. The petitioners who succeeded in getting her removed, the EC chairperson and the two deputies, they were back with a press conference. They actually said that they are going forward with a petition to the special prosecutor because, as far as they're concerned, the procurement breaches that they had alleged, which the Chief Justice Committee found to be good grounds for her removal, is enough for some criminal prosecution to also be slapped on her, and so they are proceeding. But they also claim today that they have further evidence that she was also in conflict of interest, dealing with some other private companies when the Constitution was clear that as a chairperson she couldn't hold an office of profit, in addition to what she held at the EC. Is it fair to assume their position that once the Chief Justice Committee has found that the procurement breaches were in fact done by her, we shouldn't stop there, that we should then take the second step of getting her prosecuted? You think it's a fair conclusion to reach?
Well, yes, that's a fair conclusion to reach. That is, if the finding of the Committee of the Chief Justice is founded and premised on law, and so that's a fair. I mean, the fact that a commission of inquiry or a committee set up by the Chief Justice found her otherwise incompetent or unfit to hold the position of the EC chair, that doesn't in any way operate to exonerate her from offences she would have committed as a person. And this is a general rule. I'm not talking with specific reference to the EC boss. I have a fundamentally different view of what has happened. Okay, but I'm just stating as a matter of law that the fact that a commission of inquiry has found you culpable and has removed you based on its findings does not operate to exonerate you from the commission of an offense. And so they can go. It's a logical extension of the process. But Evans, has it ever occurred to you that we aren't seeing the end of what is happening, the drama that is unfolding?
Absolutely.
We haven't seen it. Clearly, the government, the committee, the petitioners have released an unruly horse. And we don't know when we will rein the horse in.
What horse is that?
The horse of people leveling accusations and trying to cut the attention of the political actors to get those people punished. But when those accusations could be their own personal idiosyncratic views of what has happened, or they could be founded on law. And now any perceived breaches of what has happened will clearly be a national issue. And that's the unruly horse that we have released. And it will be difficult for us to rein it in. And it might be taken to illogical conclusions. Right. And you see, institutions matter in the democracy. To the extent that the way government takes decisions and the way government is held accountable by mechanisms of accountability put in place in the country goes a long way to, skew the democracy, the rights, privileges of persons in the country. Okay, and so that is where I have my fundamental difficulty. And that's where I agree with Kweku Baako. And I was thinking that my good friend and brother, Martin Kweku, would have been interested in this matter as well in the Supreme Court. Evans, I've always, and today I'm happy that I've got two other good lawyers here. Evans, we have a constitution. The constitution in Article 46 establishes the terms and conditions of the Electoral Commissioner. Mm-hmm. And equates those terms and conditions to that of a Court of Appeal judge. Mm-hmm. Subsequently, establishes the deputy commissioners and equates their terms and conditions to the High Court judges. Then establishes the judiciary in somewhere in Article 126, or what is it?
125.
125, 126. Yes, good. And then, and says in Article 144, it establishes a whole regime for the removal of justices of the Superior Court of Judicature. Not justices of the Court of Appeal, not justices of the High Court, but justices of the Superior Court of Judicature. Okay, and then says that their removal can only be premised on misbehavior incompetence and failure to perform their duties, incapacity to perform their duties by reason of insanity, sickness, and all those things. Then the fundamental jurisprudential question I've always asked myself since the beginning of this case is, Evans, is the appointment of an EC boss and making her terms and conditions conterminous with that of a Court of Appeal judge make her a justice of the Superior Court of Judicature?
Is the Court of Appeal
because you see, Article 146 is talking about the removal of justices of the Superior Court of Judicature. That's what it's talking about. It's not even talking about the Court of Appeal judge. Anybody from the Supreme Court to the High Court, okay, is subject to the proceedings under Article 146. So, truly speaking, Article 146 is the removal of justices of the Superior Court of Judicature and not any other person. Even if you are a judge of the Circuit Court, you are not subject to Article 146.
But the Constitution says...
Well, I'm just thinking aloud. This is jurisprudential. I'm thinking aloud. I'm saying that...
Have you come to an answer? Do you have an answer to that question?
I'm saying that...
What does your gut tell you?
To be honest with you, I do not think that when we were making the law, we made the law to suggest that equating the terms and conditions of an EC to that of a Court of Appeal judge, we intended that that EC boss should be subject to Article 146. That's my feeling. Because Article 146 does not in any way convert an EC boss into a judicial officer of the Superior Court of Judicature.
I see.
It doesn't. And that is my view. And I've been thinking that I should engage my colleague lawyers in exploring this further. Because you see, why do we say that the removal of justices of the Superior Court of Judicature should be in camera? Martin, why do we say that? Yes. Because those people who occupy those positions, positions of trust, need the supreme confidence of the people of this country. And that when we make it in public, when we hold their removal in public, it will shake the foundations
of the institution
itself. And that's why we should say we should make it in camera. Because people will begin to ask questions. But an EC boss is a public officer simpliciter. Simpliciter, she's a public officer. But so was it the intent that in her removal, we should make the proceedings secret? Especially so that this is an institution that is crucial. That's the sine qua non
of our democracy.
That we need all political parties and all persons, all political actors to repose some level of confidence in that institution. You get where I'm coming from. So I've been terribly worried, to be honest with you.
Yeah.
I've been terribly worried. Because you see, that's why I said we're riding an unruly horse. Why did the MPP and my good friend and brother Afonyima is here? Why did the MPP oppose the appointment of Charlotte Osei?
Like you oppose whoever Nanado appoints in the next few days.
Oh, why? Political parties don't oppose simply because they want to oppose, especially the appointment of persons. It's when they see a possible likelihood,
whether real
or perceived of manipulation.
Yes.
That is the basis upon which MPP opposed Charlotte Osei, not her capacity to deliver.
No. Does that fair that because John Mahama appointed her, there must be something more to it than just...
And then the accusation was, your mama in appointing Charlotte said it did not. You remember I was here, Gabi Ochidako was seated where Afenyumake is sitting, and I believe that today you will make those comments. and he had said that
and what were those comments?
I'm being preemptive so that you don't make those comments. And he has said, oh, you know Charlotte, you know that, I know Charlotte more than you. She had an NDC card. Okay? you make all these comments precisely because you think that her appointment was done in a way to skew the outcome of the elections. They were so deep-seated mistrust of the person and her ability to run. And those deep-seated mistrust or distrust did not go away even when she conducted the elections and won the admiration of the international community. And then a tape which I heard my brother Kweku Baako refer to about a week or two ago clearly exposes some level of conspiracy to get her out, even before the process of the petition was initiated. Then you have the evidence of the headless petition that was sent to the office of the president. And all of us know, including the president, including my good friends, or even you know, that no president has an obligation, and it's a Supreme Court decision, no president has an obligation to transmit a fundamentally flawed petition.
That's a Modibo thing. Frank Ejechun versus AG.
No.
But what is fundamentally flawed?
So what the fundamentally flawed?
And who makes that determination? The president
himself
has to make that determination.
Because if you send a petition,
but if you put that power in the hands of a politician, you're riding a very dangerous horse.
Exactly. That's why we are raising these issues. Our democracy is still growing, so you need to raise these issues.
So
and you need to raise them.
CJ who will determine
you
whether
raise them.
Exactly.
No.
So give it to the CJ.
I'm not even gotten there yet. It's a headless petition is sent. Then we are told that, the petition is headless. Then the presidency gives the petitioners an opportunity to do what?
I mean, so that the substance can be dealt with.
You understand? So
substantial justice.
If you receive an anonymous letter at Joy FM, do you give the sender? That is, if you know the sender, because it's anonymous. You are not supposed to know the sender.
But the lawyer owned that.
So if you give,
it wasn't really anonymous.
Yeah. It was really no.
The lawyer owned that.
Lawyers are only agents.
And he said that if it gets to the Chief Justice Committee, and they will produce it. And now we know that they're holding press conferences.
Evans,
we need some clarity here. Evans.
What clarity?
Let me read this thing. Then I can provide what I and it may not coincide with what my brother is saying entirely. This is a letter dated 26 July 2017. It's addressed to the Chief Justice. It's signed by the President. It's titled Petition under Article 1463 of the Constitution. In my absence from the country, my office received a petition, initially undated and unsigned.
This is from the President?
Yes, signed by him, purporting to invoke the provisions of Article 1463 of the Constitution in respect of the office of the Chairperson of the Electoral Commission, Mrs. Charlotte Osei. Subsequently, Counsel Maxwell Opoku-Ajimai, by letter dated 20th July 2017, wrote to my office setting out the names of the petitioners and the date of the petition. Pursuant to the terms of Article 1463, I'm therefore constrained to refer the petition to your high office for resolution in accordance with the teachings of Article 1463. I enclose the petition and its incidental papers with my best wishes in the service of Ghana. Yours sincerely, Nana Adodankwa Akufo-Addo. At the committee level, the petition itself turned out to be unsigned. The petition itself, unsigned by any of the petitioners, including the lead petitioner who came to testify. Do you get that extension? Yes. But whatever happened at the presidency before the forwarding, if you read this carefully, there was a lawyer who did a subsequent action by sending names of petitioners, which he said they would disclose at the appropriate time if required to do so. That is it.
That doesn't solve the problem. In fact,
but as I said, it will not totally coincide.
It confirms exactly to what I'm saying. I was not privileged to this information. But I'm just talking from my legal point of view. Okay? If you file, Martin, or if you file a process in court and the process is fundamentally flawed, are you given an opportunity to amend it.
You can be thrown out just
It's thrown
on
out.
the basis
And
of that
you
flaw.
might ask for an opportunity to correct, and come back. Okay? So even it depends actually. It depends because it could be issue, you could be affected by issue estoppel or process estoppel. You understand? So so that's why I've been thinking. And I've been saying that, well, does it bode well for our democracy? I shudder to think that it will not. Because now, back to the unruly horse, the petitioners have gone further. They're saying that the tape revealed the voice of one, what's his name? It's from DZ.
Pauline Jajawa.
Pauline.
And that
I've never
steps
been
should be
able
taken to do what?
pronounce that name.
To remove her. Now, the logical outcome of all these things will be the dismissal of all the 7 commissioners. Then we go back to 1992, and probably thereafter.
But even without that, the
Yes.
president will appoint almost all the 7.
Yeah, that's what I'm saying.
By 2020.
That's what I'm saying.
Yes.
That's exactly where I was. You are getting the drift of my argument. That you have a president whose party opposed the appointment of one
So
person.
what you're saying is it feeds into the suspicions before this process started in the CJ committee that there's always been a plot and orchestration to get her out. And this was just, they're using legal means to achieve a political end.
The unintended consequence. Exactly so. They are using the legal means. I mean,
Not even a political end.
Oh, Evans, and in Ghana, Ghanaian law is replete. Ghanaian court practice is replete with using legal means to achieve a political end. Replete. I can give you.
Are you speaking from experience?
Oh, I can give you many examples, even dating back to the time I was not born.
I want one from the
PDA was PDA.
Yeah.
Replete. And so I'm not talking about that. I'm saying that even the unintended consequences of the act, again, the unruly horse, the intendment of the political actors, if there was only any conspiracy to get Charlotte out, was to limit it to Charlotte.
No, but let me bring in. I'll come to you, Afenyo, short, because I know you made a lot of notes. But because you are the neutral person, you're Kweku. He makes the point about the unruly horse, etc. And this week, the petitioner said they're going to the special prosecutor. He agrees that in law, that makes sense, because if the committee has made all these findings that you broke the law, then it must follow. It begs the question then, it defeats a second argument, doesn't it? That if there is a real legal basis to remove her, there is a real legal basis to remove her. Whether you suspect a conspiracy or not, or the people were faceless or not, so far as they brought evidence that checked out, that's what matters.
That's it.
Everything else is moot.
That's it. Of course, you see, naturally in life, you will have some collateral benefits. So in this case, the political advantage is a collateral benefit. But in life, that's how it happens. We call them low-hanging fruits, right? Yeah, you always have low-hanging fruits. You have the major one, but you always find in life low-hanging fruits. It's a collateral advantage or benefit. But when it comes to the substance, for me, look, we've made a monumental improvement in our governance, because you see that, as we stated last week, it just didn't start with this EC chair. It started with the announced expose on the judiciary. You say, yes, then we came to the Shraj matter, and now we are on to the EC. So it's shown that in the last couple of years, we have made very serious attempts, and we've won at making sure that governance improves, both in the justice sector and also now the electoral system. So for me, yes, it's painful. Yes, Madam Osei did well, the elections, yes, we had it peaceful and all that, but it's unfortunate. I mean, this had to happen, and once it has, we've learned. Because you see, let's not kid ourselves. Those matters that happened were quite serious. You see, that Constitution makes it clear in Article 37, and the Chief Justice referred to it in the prima facie determination. You're looking at probity and accountability, you see. So where you're put in charge of an office and then there is due process for awarding contracts. You yourself, when you came in, you saw that your predecessor, you're saying that certain things didn't go well in terms of the STL contracts. You canceled them, and then you did the very thing, single-handedly awarded them in the same manner as the ones that you canceled. Then the question is, did we go or we came?
Question.
Yeah?
Must Charlotte be prosecuted?
Yeah, that one, to be candid, you know, looking at it, because of a discourse, some weeks ago I had mentioned that it was sufficient that she was removed. Because, you see, to be very candid, I'm looking at the political and social context in Ghana. We have just started this string of removals where we are holding public office holders to a certain level. So I think we should go a bit more and see how it reflects on the rest of the public sector. So if you ask me, really, I'm not vouching for, I'm not in support of the criminal prosecution.
You think the removal is enough?
Yes. That
although
is it,
although your first point is that she broke the law.
Yes, yes, yes. And for me, the removal was enough. Because you see, now she suffered this, a lot of punishment, and she's ruined. Because it means that, look at them, look at the breaches, not just one, not two, not three, 4, 5, 6. And the committee made it clear that this is a pattern. For crying out loud, how much more can you destroy a person? So for me, I think that in the context, perhaps the prosecution is not necessary. They are more, what do you call it? Rather, they can look for, if you want to, unless you establish that we really lost so much because of the unilateral award of the contracts, yes, then that's a different kettle of fish. So if you establish that through these breaches of the procurement law, we lost so much, maybe, so let's say that the $40 million contract, right? If, let's say, the same could have been procured for, let's say, $5 million, then it's a different matter. But if you just come that breaches of the Public Procurement Act, so let's prosecute. It's not
That's
good.
An important point you've made. So do you support then the petitioner's goal of petitioning the special prosecutor, who will then investigate beyond what the Chief Justice Committee did to see if restricted and sole sourcing were used, okay, whether we had value for money?
Exactly, for that one.
So you support the petitioning of the special prosecutor? Because he then can make the determination of whether monies we lost out because of the approach to the procurement.
Oh, certainly for that one, it's worth investigating. Then it means that the petitioners haven't articulated their case well, because they just, from what we are reading, that, oh, because there were violations, then let's prosecute. So I'm saying that, you know, under the Public Procurement Act, for such violations, you are looking at, in terms of imprisonment, not more than 5 years. And then when it comes to penalty units, I think 1,000, not more than 1,000 penalty units. One penalty unit is 12 cedis. So you multiply 12 by 1,000, and then you get a figure. So what I'm saying is that, so if you're just saying that because she's been found to have breached public procurement law, so let's prosecute that one, I'm not in favor, because there's more work to be done. But rather, if you say, let's investigate how much we lost, value for money, because of the unilateral award that's of those contracts, the sole sourcing, that one, yes, is good for us to get to know. Because, you know, now the way our jurisprudence has developed, you see in the Wyoming case, when we didn't get any value for money, the court said, no, refund it. So let's investigating to find out whether we got value for money. That one, any day, I'm in favor. But not the mere prosecution based on the finding that there's been a breach of the Public Procurement Act. Because there are still a lot. Do you hear that? I mean, so many people are owning up in public office that, hey, this and that has caught Madame Osei. I mean, we too, we generally have been breaching. You see, there have been those comments that people have said it in private. So it tells you that generally it's a problem within the system. So if somebody suffered the first one, that's removal. In the context of so many other people who haven't followed due process, I would say that we shouldn't just prosecute just because of the breach of the law. But we can investigate to find out how much we lost. Then we can take it from there. And then one more comment about this unsigned petition. You remember last week you mentioned it. This very Wyoming case is Martin Amidu in the Supreme Court. He failed to sign his processes. It's a binding Supreme Court decision. The Supreme Court looked at it and said, no, look, once in the context we can ascertain that this is coming from Mr. Amidu, the failure to sign did not nullify the process. Aren't we all happy that the Supreme Court ordered the refund of the money? Yes, yet the processes that originated, that led to the refund of the money, were not signed. It's a Supreme Court decision.
No, but you're talking about two things.
Yes.
You're talking about public policy. imperatives. And you are talking about the protection of the fundamental rights and liberties of a person. They are two different things.
Which one is?
Go to Article 23. The removal of Charlotte Osei affects her human rights.
Yes.
Okay?
Yes.
It's a different matter.
Yeah.
And the fact that the Supreme Court was willing to waive the unsigned process of Martin Amidu is a public, a public policy issue.
For me, I think it applies because where was it headed? Well, Mr. Amidu was headed towards disgorging 50-something million from.
So public policy required that our money, wherever our money went, we should look for it.
And you don't think that
that's a public policy?
Oh, then it's even more instructive in this case. Article 37 says probity and accountability. So when you find that somebody is breaching probity and accountability, which is stronger? In actual fact, which one is stronger? If you ask me any day, this is stronger. Look at it. Let's let me read a bit of it. Article 37, clause 1. The state shall endeavor to secure and protect a social order founded on the ideals and principles of freedom, equality, justice, probity, and accountability, as enshrined in Chapter 5 of this Constitution. So the CJ says, look, in the prima facie determination, she understands the Public Procurement Act as one of the tools used to ensure probity and accountability. I mean, you can't totally erode the force of this reasoning. It is sound. Sound to the highest level. So for me, look, that signing of the petition is neither here nor there.
The substance was more important.
Yes, we've done substantial justice, and it didn't start today. Even last week, I referred to an earlier Court of Appeal decision, 97-98. It was also Martin Amidu failure to sign a court process. And the Supreme Court said, the Court of Appeal, they're looking at the case. We will continue. It will not nullify the proceedings. So it's always been part of our law that there are cases in which failure to sign your process will not nullify the proceedings. So Charlotte Osei's case is not the first. It's not.
Alex,
97, that's over how many years?
Where do you stand on that debate of what the petitioners are seeking now? Prosecute, petition, special prosecutor, they want that done, not just removal.
Well, it is not about the perception or how somebody feels about it. It's a matter of law. If you breach the law, what does the law say? Yes, of course. I mean, so it's not about somebody exercising, well, the AG or the special prosecutor would have to exercise a discretion whether or not to prosecute. But I'm saying that if petitioners are well grounded and the law supports whatever action they expect the AG or the special prosecutor to undertake, obviously nobody can stop that. But let me answer a much more fundamental question raised by my friend and respected colleague. The issue of unsigned petition. He tried to argue, and he was at first talking law. When he started doing his NDC politics, he contaminated his whole argument. You know, he contaminated the argument.
I knew this was coming.
And I had to just watch him. You see, Uncle Kweku Baako was very candid. See, the president knows the politics of this country. So he was very specific, made reference to the petition, unsigned petition, the subsequent communication he received from the council, and all that. So he left it as it was, which is fundamentally different from what my respected colleague was trying to put out there.
In other words, the president made the Chief Justice aware of the deficiencies that may be in the original
He
petition.
left it as it is.
He didn't just send it. He wrote
Of course,
pay attention, there are these other issues.
And
I'll leave it to your judgment.
Exactly. So for you to now come and...
NDC politics?
You know why I kept quiet? Because I wanted to respond to you.
I'm sure he will see very soon.
Well, I'm waiting. I'm waiting to listen.
So the president did not do anything. Don't create the impression
that NPP politics.
Don't create the impression that some unknown persons wrote, and the president could have exercised a discretion not to forward. Don't create that impression at all. Don't ever do that again. That is bad faith. Never. 2, unsigned petition. I will add 2 more cases. the Tachuchikata case. A writ was issued, a criminal summons was issued in the name of the president.
Oh, allow him.
I will come there.
You know when you were no.
The court rules.
When you were speaking,
you can't use technicalities.
He made notes.
Please, it's not our petition.
Please get him a pen for me. Get him a pen. No, you want to loan him your pen because then he will stop.
Yeah, so I can.
Please, yes.
I gave him my paper, so I can give you a pen.
You have
now he has your pen.
you have indicated that you are leaving
Please,
Parliament. You want to be
two cases.
You want to be a statesman. Why you?
Alex,
I've written
proceed.
The election petition is here.
Yes.
Where I've written refusal to sign does not invalidate the result of the pink sheet.
Yeah.
I mean,
exactly.
Justice Atuguba who wrote the late judgment. That's how you want the case. It says so. So
you are inviting him now.
No, I'm not. I mean, these are rhetorical.
Good.
That invitation is supposed to keep quiet and just take it. So let's not get in there. In any event, the petitioners showed their faces. But is there anything on record that Mr. Tadiosori raised a preliminary legal objection on those issues that my friend is trying to?
If it was, we had not read it in the Senate.
And if those preliminary legal objections were raised regarding the nature and form of the petition, were they refused and were all upheld? Let's also look at it. But the most important thing here is that there has been full trial. The respondent has not come to complain.
Not yet.
Yes, the respondent has not come to complain to NDC. Yet the NDC is crying foul. He said that...
Kweku is too.
Don't worry, I will address Mr. Baako's case. At least he had issues with the law and he's going to the Supreme Court. And I respect him for that. He is not organizing a demonstration. He is not attacking the president. He says that I have a fundamental problem with the law, the procedure. I want to challenge it, and it's the right thing to do. He's demonstrated his deeper understanding of issues. Unlike a political party that through one of its representatives last week said that the breaches were mere breaches on this platform. My respected colleague, Defia Makpo, I watched him. He said these were breaches. He considered that they were breaches. But speaking on behalf of the NDC, echoing the views of the NDC as a political party, my respected colleague said these were mere breaches. So fundamentally, the NDC, upon all the pretenses, concede that indeed there were breaches. But according to them, these were mere breaches. Well, the politics of it. You see, we are talking about developing institutions. And if each time institutions try to assert themselves, we turn around to bastardize them, then I'm afraid we're not going to get anywhere. Is it the president who has removed Charlotte Osei? Or it's an institution that has done its work in accord with law and has thus made a recommendation for her exit? The NDC may not be happy because they appointed the woman to head NCCE. They tried to push her to the Supreme Court. The Judicial Council did not agree. She was rejected, and eventually she was sent to the Electoral Commission. The MPP as a party opposed the procedure for the appointment of the EC chair, and I led the charge. Eventually in court, my client was Richard Sky. It was not Charlotte Osei. They shouldn't get it wrong. The MPP opposed the procedure. However, we looked after if the eventual appointment and the decision by the Supreme Court endorsing the procedure and all that. You remember I even raised the issue of contempt, that while the matter was yet to be tried, Mr. President had gone ahead to appoint an order, and I felt that it was unappropriate. But look, it didn't get anywhere. We as Democrats accepted it.
You contemplated contempt.
Yes,
the Supreme Court asked you to think carefully about it.
Oh, you were there? Yes. Whether or not I had any injunction application there and all that. So we let it go. We had a problem when eventually...
Whether or not you could injunct the president in the performance of his functions. That was what the Supreme Court was telling you. Not that you had an application.
No, but if you had an application, no.
Okay.
You were not involved.
Okay, he got that interjection. He's responding to. Yes. Proceed.
I will get him in Parliament and deal with it. So, when Charlotte was appointed, as a party, we had issues with the background. And we did not hide from that. Yeah. But it was not an NDC, MPP person. It was not Kennedy Japan. It was not Gabios Asardakun who petitioned the president for the removal. Get it straight. Now, on the removal of the deputies, I can say on authority, and the NDC as a party is aware of this, that a card-bearing member forwarded a petition to the president on Mrs. Opoku-Amankwa and Ahmed Usile. I am saying.
Who is this card-bearing member?
Oh, but they know. They know. It's on record. That one is not an EC official. The person is known, a known card-bearing member. What is their response to that? Why are they silent on it? Is it about Charlotte Osei? As for Ahmed Usile and Opoku-Amankwa, should we also contend that you, a member of your party, having petitioned for their removal, you had an interest in ensuring that they don't work in that office? Should we make that contention? Why are you silent on that? Bad faith, once again. Bad faith, mischief. So let's allow the system to run. Angry Kweku is in the Supreme Court. Let's see how the debate will turn out to be. It is good for our democracy. And one person who has always been saying that, look, let's leave the gallery politics. We do the gallery talk, let's go to the appropriate forum. We were always lamenting, my lord, grant bail. They say, oh, this was unbailable offense. It took Martin, my respected senior there, to boldly go and challenge that issue. And we got a ruling. Yeah. So why are we not ready to use the system? Why demonstration? Why would you want to go on a demonstration? Why? And even lawyers who know the law, who are lawyers well respected for their procedural acumen, will now, with mischief, try to attack the president and the government and say, why? Though you were in a comfortable lead, we beat you by 1 million. In a comfortable lead with her. So why do you think that we are afraid of Charlotte Osei as a person? That as a party, if Charlotte is there, we can't win the next elections? You failed to implement the free SHS policy? You said you couldn't restore nursing training allowances? You couldn't deal with the youth unemployment? At least an effort has been made in the short term. NAPCO, the first NDPP administration, rolled out many social intervention policies, implemented them successfully, which you came and you were not able to introduce a single one to add. Your SADA failed. It collapsed in your hands. So we have a track record upon which we'll write to another success. So don't trivialize this matter.
In other words, whoever is at the EC will not affect your fortunes in the election.
We know our work, that we should work and deliver. Ghanaians at the end of the day will look at the issues. Did you deliver? Did you talk about free SHS? Have you delivered? Restoration of nursing training allowances. Have you delivered?
So those are the issues that will determine whether you win, not the
Corridor Road. The Eastern Corridor Road.
I mean, I want you to make the point because I need to.
Yes. We need to add all of these to make it complete. So allow me, my brother. So it is not about Charlotte Osei.
Okay.
And let's allow the law to work. Don't let us truncate the process. We cannot continue to politicize almost everything. And I would want to urge my colleagues. Yes, there is, again, you can get some mileage in there. But there are some of it that the excesses of same will not help our democracy. And that they should be minded of these. And I'm sure that if they look at all of these and they act in good faith, it doesn't matter who is there as EC chair. This man who retired, Afarijan, he was there in the 90s. You won elections. Kufuor came, we won. 2008, Professor Mills of blessed memory won. We lost by less than 40,000. He conducted it again 2012. We went to court. Eventually, your own Charlotte Osei. Now you are owning Charlotte Osei that she's one of your own. You have a direct interest in her leadership. Yes, you must. Because I restrained myself.
No.
I didn't heckle
myself because he started by chastising me. That was doing NDC, NPP politics.
Now he's
more than 40% of his submissions now are politics.
Yes, but that's what I'm doing.
You understand?
Yes, but that's what I'm doing.
But the point he's making is what you've accused him of is
that's what
he's
you have done.
probably done worse.
I need to first.
Don't ever do that again to me. Don't ever.
But
Don't ever do
let
that.
me finish.
I'm warning you. Don't ever. You see? Because no. You should know that. Don't ever do that to me again.
Okay.
Don't ever.
So
is it done?
Yes.
No, but okay. So that's what I wanted to make the point. Let's talk about the EC.
Hold on.
Wrap up for me. Let me hear from people.
You've allowed him to.
No.
He's
taking it to the extremes. No.
Honorable, don't address him. Address the issue. Address the issue.
The NDC. Don't worry.
No. Can we address the issue? Let's address the issue.
I won't be moved by. I won't be moved by sentiment and lamentation.
Honorable, no. Address the issue.
We
are here to discuss
overly emotions.
And I think you may. I would like to, if you don't mind, I'll come back to you because we'll do a second round of this. Let me hear from you. You found the judgment.
Please.
So wrap up for me.
You can't just switch.
Briefly.
The man is getting emotional.
No. Just wrap up for me.
When he was throwing the jabs, he thought I couldn't respond. I kept quiet.
No problem. Alex.
Why is my colleague lawyer? We know how to do this.
Yes.
Why? Don't look into my eyes.
No.
You are frowning to do what? To intimidate me?
Alex, no, it's not intimidating you.
Please.
Let's address
I kept quiet and took it all in my stride.
No problem.
You should take the point.
We've spent the last 2 minutes trying to do it.
Premise you filed. You filed the premise and you have engaged in fallacies of argumentative reason.
It's agreed to go to the issue.
Throughout.
It doesn't matter.
Throughout.
Let's go to the issues.
The fact that I doesn't mean that I will not do what you say.
We need to move on.
Okay, very
well. Go on.
So let's shake hands.
Shake hands.
I don't have a problem.
Thank you very much.
But don't.
Right, so let me conclude. It's all right.
Thank you very much.
It's all right.
Let's move on.
I've accused you because you did something bad. I've accused you.
Yes.
But you are not happy. So you forgive Don't do that again. The NDC has acted in bad faith.
Junior lawyers do.
Wow, that's another one.
That's very right.
That's a good one.
He has trained me to
Go on.
The NDC has acted in bad faith. The NDC has been inconsistent on this Charlotte Osei thing. If there is anything partisan in this EC matter, it is rather the NDC as a party that has orchestrated same by sponsoring a card-bearing member.
No, but you can't prove
Oh no, I'm making a point. When I land, you would know whether or not I've proved it. I've made a case.
Okay.
By sponsoring a card-bearing member, unless they would say they are saying that they could not restrain their card-bearing member, who subsequently petitioned the president on Ahmed Usule and Mrs. Opoku Amankwa. Unless they are saying that they couldn't restrain him, unless they are saying that they are disowning that card-bearing member, unless that's what they want to say. But in the absence of this, it is my contention that they sponsored that member of theirs to also petition and to, as it were, equalize. So they should not pretend that Ahmed Usule and Mrs. Opoku Amankwa do not exist. They should not pretend they do not exist. If they are talking about the principle and they are talking about procedure, look, this morning we are talking about MPP having gone to court in the 90s. Yeah. We have talked about J.H. Mensah. Yeah. I am yet to see an NDC. They have well-respected lawyers. My colleague is one. I listened to him. I learned from him. NDC as an entity, as a legal person, can issue a writ. They should do so. They should question. They can join the suit. Kweku Baako is in the Supreme Court. They should put all their views together, deal with it, and go apply to join. the court would allow them in.
Let me bring you Kweku now. Kweku, so your suit, that's a fantastic point to come to you. It says the party should join. Would you mind if NDC joins?
Well,
there's one seat already there.
I am at the Supreme Court in my capacity as a citizen of this land, this beautiful country of ours, to help to see if going forward we can fine-tune the processes and procedures relative to Article 146 and all those that come under it. That's my basic purpose. But let me be very honest with you. I'm going to resist the temptation to interrogate the issues I'm raising at the Supreme Court here.
Yes. Very important.
I won't do that, to be honest with you. I suspect, maybe I'm wrong, this suspicion may be unfounded. That's why perhaps Samson is not here. Since he's my counsel, and I could see the invidious position in which he would have found himself presiding over this discussion and all what has happened. So I'm sorry to disappoint viewers and listeners that I would not discuss the case that I've sent to court. The drift I get from the topic was that the petitioners have come out, they feel vindicated, and they are also pledging to forward some complaints to the Office of the Special Prosecutor. That is not in court. That could be discussed. But the point really is this: I still haven't seen any particular complaint that they are putting forward.
What they've said at the press conference borders on the procurement violations.
Yeah, that's what I'm saying.
Yes.
That's different.
Yes.
Because in your introduction, I got the impression you were talking of somebody holding an office.
Yeah, they actually mentioned that too. They said they have that evidence too.
Which office?
That they haven't provided the details.
Exactly.
But they're claiming that there's some conflict that she was in that they'll bring to the attention of the special prosecutor.
So we wait. Because they had 28 allegations as part of their petition. The Chief Justice, in doing the prima facie determination, dismissed 21 or 2. Yeah. Part of those that were dismissed was this thing about holding an office, the Ghana reinsurance thing. So I don't know if that's what they're going to do. It was dismissed as frivolous. Only 6, or if like 5.5, went to the committee. I'm not going to discuss the work of the committee because it's part. It's going to come. Yes, it's part of the thing. So, assuming they brought forward the fresh allegations that is intend to present to the Office of the Special Prosecutor, one will be able to deal with it. The procurement breaches, which they have referred to, again, is part of what I'm disputing, whether if they indeed were procurement breaches. Because if you go through the testimony, I have a different opinion of those things. And even if they were, whether they had to attract the sanctions that were brought. So again, I'll be very careful dealing with the issue. What they are doing is they are right. It's the rule of law. They are citizens of the land. They think that there's something basically wrong that Mrs. Charlotte Osei did in the face of the law. A committee has perhaps given them some little more weight, so they want to go to another level. Rule of law, due process. Mrs. Osei would have the opportunity to defend herself at that appropriate forum. After the special prosecutor, he would do investigations, after which perhaps a decision will be taken to go to prosecution. And I heard my good friend Martin indicate that they would investigate and prosecute solid cases and not hearsay.
True.
That's very but it's very controversial because I don't understand what that meant.
No, but he means to say that you should come with your facts,
I don't
using gallery stories to.
Don't just listen to stuff.
Sometimes those help. Look, let me show you. Even in India,
but then no, he won't work.
Oh,
because if everything I hear on radio, I can stick to
then waste your time.
Oh, it's through the flimsy that.
By the way, let's allow Kweku to make it.
Basically, he's right. Basically, the special prosecutor was right. He would not investigate just hearsay. A lot of these allegations were hearsay. The Chief Justice dismissed those ones. So he will look at it, investigate, fine, but prosecute hearsay, you will lose. Yeah. I mean, you are the lawyers. So I think that's what he meant.
Okay.
He could investigate.
So you see that
the investigation will show the hearsay nature of what you brought. Yeah. And on that basis, no serious attorney or prosecutor will go to court. That's the bloody truth. You know? So I think that we should wait for them to bring forward their petition to the Office of Special Prosecutor. We will have something to chew on. But one thing is clear, in all this, based on my own research, my own scrutiny of so many things going on in this country relative to procurement, I see the Pandora box of procurement breaches opened.
I think that's what you said. The ruling house.
Yeah, we all agree. But there's always a first time.
No, it doesn't matter. It doesn't matter. I'm still insisting. It doesn't mean that somebody will necessarily be found guilty of perceived or real procurement breaches. It doesn't mean that.
But isn't that a good thing?
I'm not against it. That's why I said it doesn't mean that the mere fact that you cite somebody for procurement breach means that necessarily he will be guilty in the face of the law.
That's true.
That's the point I'm making. As for the noise about appointments of EC members and chairpersons, we've lived with that for a long time. It's about time we stop. Okay, from 1992, when the appointment of the INEC members came in, we protested then because of the nature of the transition. The PNDC that had formed the NDC was the match commissioner, the referee, the assistant referee, a player, and a spectator. And we thought the field was unleveled. So we protested. And even indeed, we insisted that party representation should be on the committee. Togo and the other French-speaking countries were doing it. Of course, post-92 elections, things began to improve in terms of the electoral reforms that we agitated for. So the appointment per se was no longer the key, in the sense that now we had transparent ballot boxes. We had photo ID cards. It began in a progressive manner. Okay, party agents were trained.
Credible register.
Credible register. So when these things come on board, and don't forget, it's the same thing with the election petition. Though the petitioners lost, it triggered some level of electoral reforms. Some other citizens added to it by going to court subsequently. For instance, giving the pink sheets to party agents.
That won them the election.
So really now, no, for me, I don't lay too much emphasis on the appointment per se. Of course, the person must be qualified according to the Constitution. He must be eligible as a member of Parliament and all those things. It's in the Constitution. Okay? Otherwise, you have to go to the heavens and bring some saints and angels to be Electoral Commission members. So nothing stops the president. And my case in court, we are not seeking any injunction.
Okay, that's good.
We are not.
So we need a substantive.
We are not seeking an injunction to restrain the president from appointing. No, we are not. That's not part of our reliefs. So the president is entitled. He could go on and do the appointments. The arguments will start again. I remember I was on the side of those who said, let's have broader consultation when it came to the appointment of Mrs. Osei. Our friends in the NDC opposed it. The president and his side were for it. Let's see whether
down the shoes on the other leg.
Yes.
So you're still for that, right?
No, I'm still for that. I'm still for. I'm not saying it is constitutionally prescribed per se. That's not what I'm saying. But you see, because of the political nature of the EC, the work it does, sometimes if you build a consensus, you aggregate a certain national consensus relative to the appointment process. It does help. That's all.
Quick comment. I'll come to you. I know you want to read it. Quick comment on the EC finance officer who has complied with the Chief Justice Committee's recommendation to return the money. In fact, he returned far more than he was asked to. It makes the question whether there's more that we need to probably look at.
I am wondering what exactly is the issue here. Is it the endowment fund, or it is the EC, the political
party stake? The $5 million was given to Amadou Sule, that was spent, and the rest given to the guy to hold on.
At a committee level,
it was a 360,000 Ghana cedi.
Yes, I'm not sure what testimony, whether the gentleman was invited. What testimony he gave.
He said that he was given to him for safekeeping.
And the money was kept in a safe at the EC.
And that the reason why he hasn't let it go because he had not been reinstated.
I wonder if the committee took the time to go and inspect the safe and the contents of the safe as part of his work. Okay?
Yeah.
When the testimony was
That's
given,
an important point, actually.
that this money is here, it had been there for a long time.
Yeah.
It's a subject of inquiry by a committee of that nature. I don't know.
Somebody should have
Maybe
verified.
they did it. Maybe they did. Yeah. But if they did, now here we are. He's supposed to have brought more than he was asked to bring.
He brought 70,000 plus more.
That's why I'm asking the question I'm asking. Did the committee avail itself of the contents of the safe? And for that matter, the records that were kept relative to the safe? Because you see, one thing about that money, when it came to the internal audit report of the EC, you realize that those monies were transmitted to regional staff of the EC, and they kept it in their own accounts.
Yes.
So again, there's the need for tracking in terms of accountability.
True.
So I don't know that aspect. But well, if he's brought the money and he's decided to be patriotic and nationalistic to add more to it, we shall find out.
So thank you. Yeah. Quick 1 minute each as we wrap up, and then we'll take a break and return with our next.
So I think I should read out a very instructive part of the committee's report, because so far, you know, in the comments, you don't hear much about what the committee really wrote. This is the judgment, excuse me, of the report. The report says, for all the allegations against the chairperson on procurement that this committee investigated, no evidence was adduced to show that the Electoral Commission established and used an entity tender committee with a membership as composed as required by Act 663 and Act 914 described above. The PPA Act, that's 663, as amended, required all procurement entities to use its entity tender committee to evaluate tenders unless the procurement activity is sole or single sourced. The evidence before this committee is that the commission only had a tender evaluation panel headed by the Director of Finance and most times 4 others. By Section 19.1 of Act 663, this tender evaluation panel was supposed to be an ad hoc committee established only to assist the entity tender committee in its work. However, it seems that at the Electoral Commission, this ad hoc committee took over the work of the entity tender committee. What was happening at the Electoral Commission was that the tender evaluation panel evaluated tenders and then submitted reports to the chairperson, who was supposed to be the chair of an internally created entity tender review panel with membership made up of the chairperson and the 2 deputy chairpersons of the commission. It is important to stress that this entity tender review panel created internally had no backing of the law. What Act 663 and Act 914 did was to create a central tender review board under Section 21 of Act 663 and Section 20F of Act 914, which is supposed to approve tenders above the threshold of the entity tender committee as created by the Act.
Okay, and so the point is?
So the point is that, look, the entity tender committee required to be created by law was never done. Okay. So and let's even add, that committee was supposed to be made up of some MPs and persons from professional bodies. It had persons
for the EC?
Yes.
Okay.
You see, so it wasn't just supposed to be made up of the directors of the EC and that. So if you fail to create such a very important body to ensure probity and accountability, you can't be heard to say that these are mere
and yet you don't support a prosecution.
Yes, but
again, the temptation gets greater.
Yes, but
I tell you,
no, please. He's tempted. Allow him.
I will not go into details. It's disputable.
Yes, please.
Yes.
This ruling is disputable.
Why?
The time will come.
Oh,
no further.
You whet the appetite and then you back
no further comment.
In fact, the
There's a-
decision is disputable. But I won't comment on it. But obviously, because Kweku is in court, we just leave it that way. But again, Kweku says, and you said, will breaches of the entity tender, the Procurement Act, necessarily lead to a removal? Then I shudder to think what would have happened if the law were applied in the case of NCA and the extension of the contract of margins.
Okay.
Because even the procurement board was not in existence.
So there should be a petition?
Well, I'm just thinking aloud.
Oh, okay.
Now, you mentioned that Matramidu said that he will only prosecute serious cases.
Yes.
I had great difficulty when I heard that statement.
Why?
You see, this is a
briefly, because I'm not
this is a
discussing
country
that.
where we are into partisan politics, and where people feel strongly that a case must be investigated, and it touches the other political divide, and you feel to investigate it.
Using that excuse, for example.
Using that excuse, for example, then it lends credence. It will lend credence to the fact that you are prosecuting only political. You shouldn't have said that. You see, in Malaysia, even a 5 cedi bribe was investigated. 5 cedi.
A bribe is a bribe.
A bribe is a bribe. And so that is it. The third thing is that this is not about politics.
Okay.
I have said that when NDC lost power in 2000, I went with NDC members to national security. They are invited. And I was telling the national security guys that they should do their work well. You know the Irish three who were convicted. There were 3 or 5, the Irish guys who were
eventually
convicted.
overturned when they realized.
So many years. Yeah. So many years later, it was overturned.
Yeah.
Because they had procured the evidence.
Yeah.
Always know.
And the Birmingham.
It's true. Yeah.
Yeah. You should always know that the situation is never going to remain the same.
Okay. Briefly.
The situation will never remain the same. When we lost in 2008, 2009, 2010, we're always in court. I remember times I stayed at the BNI midnight. You will not have access to your client and all that. My advice, because of our persistence on some of these issues, some BNI officers were removed. I don't want to mention their names here. They were forced to swear out because they felt that they were giving access to our colleagues working at NHIS and all that who were forcefully removed from office. So, yes, if we agree that let's follow the law, the partisan politics will be there, but the law would always be supreme. I think that whatever concerns Mrs. Charlotte Osei has, the law is the only means to get her remedies upheld. I mean, given her. So, all those who disagree with the position should use the law. I respect her as a person, although the party disagreed with the procedure of her appointment. But I remember there was one, if you ask me to choose between Dr. Afarijan and Charlotte Osei, I would choose Charlotte because Afarijan was very snobbish to concerns that I pushed to his office.
Charlotte
he wouldn't even respond. But Charlotte at least saved another court writ being issued by me because some illegal, unauthorized transfers and proxy votes were approved. Yeah. And she openly said, no, these were not authorized, and responded to my petition and removed them. Okay. So, I mean, yes, I mean, these are facts. Okay. But a body headed by the CJ, I mean, a body all put together by the CJ has done its work, made up of a Supreme Court judge, Court of Appeal judges, and other well-respected members of society. Yeah. Let's not, because of partisan reasons, overly condemn their work. Okay. Let's challenge them using due process.
Thank you very much. And we'll take a short break, and when we return, the GFA, the court.
Even by the way, Casfodians, you know I'm a Casfodian.
Yes.
Casfodians.
Yeah, bringing a girl.
Casfodians, no, we don't do that. We are gentlemen. Casfodians are saying.
Is it Katanga? Okay, the Katangis.
You Katangis do that.
Yes, yes. They do what?
You do that.
No, sorry.
What you just said.
No.
Oh, you didn't miss it.
What are you going to say?
Well, you know what you said. Casfodians are saying that Senior Fuseni was trying to bully me.
Oh,
I want you to tell them that you don't bully.
No, I don't bully. I don't bully. I took exception because when you said I shouldn't have engaged in
Then he did it.
I thought you wouldn't do that.
And then he did it. Even the more than you did.
That's what I took.
Yes. No, but you should count it. Thank you. We take a break now. When we return, we will examine why Anas Anas has taken a fellow journalist to the NMC. And the court this week formally appointed a liquidator to liquidate the assets of the GFA. The implications of that when we return from the short break. This is Newsfile. Stay with us.